Welcome to the Family Law Advisor video podcast. My name is Ryan Bauerle and I'm a family law attorney here at GoransonBain Ausley. Our purpose with these video podcasts is to have a candid conversation about family law and divorce during these very uncertain times. We want to share information, updates, and resources to anyone who has questions. Today's topic is on the COVID-19 restrictions in parenting time. The short answer is that it won't or that it shouldn't. The Supreme Court of Texas weighed in on this and said specifically that the existing trial court orders are supposed to control in all circumstances, although, of course, parents are certainly able to agree to deviate from it, but absent agreement otherwise, they need to stick with what the order says. The link to this order will be available on our website. While it's clear specifically as to what the Supreme Court of Texas says, what's less clear is how different people interpret these orders or these agreements. So, the Supreme Court of Texas has said that this is an emergency. While this is a national emergency, this is a state and local emergency. That's not the same type of emergency in the eyes of what your judge might think that might justify getting some sort of TRO or other ex parte relief. So just because maybe the other parent is deemed an essential employee who still goes to work every day, comes home and sees his child, and the other parent might be concerned about possible exposure to the virus, that is not sufficient evidence to go get any sort of temporary restraining order. What a court will expect to see is some sort of true imminent danger to the child and that the court feels it needs to act right away. Courts right now are only hearing emergencies anyway, so these types of things should be very specific and there needs to be some sort of specific danger to the child, specifically in regards to the corona confines that we're talking about. I assume the situation would be rare and almost unheard of. What you're more likely to see is just parents not taking the situation very seriously. So one parent, not necessarily listening to the stay-at-home orders, maybe not wearing the appropriate face coverings like they're supposed to, that kind of thing, not enough to get any sort of restriction on parenting time. But in the unlikely event one parent were knowingly and intentionally exposing their child to exposure, then the court might consider granting some sort of relief in that very limited circumstance. Again, this is pretty rare, but presumably you could contemplate circumstances where this might occur. For example, Texas has restricted travel from the state of Louisiana right now. So if the child is in Louisiana or headed to Louisiana, that might just make visitation impossible. Granted, alternate arrangements should still be made. There are other ways to get from Texas or to Texas, so the court will still expect parents to do what they need to do to make sure the order is followed. Sometimes, however, it's just impossible. In those very limited circumstances, make up time for the parent that missed out should be considered.